I'm going to let Karen Ziff handle the moderating of this panel. I'm getting good at delegating, so I'm just going to introduce Karen and jump off the stage. Karen Ziff was our fellow last fall, and for the fall, right? Yeah, you didn't stay part of second semester too, no. Karen did a PhD at the University of Georgia under one of my favorite historians, Emory Thomas. That's a long story, but I won't belabor it. And her MA also at Georgia under Bill McFeely, which is another one of my favorite historians. Her BA at Wake Forest. She's been teaching since about 2001 or 2000 at East Carolina University. Also taught briefly at North Carolina Wesleyan. And has published all kinds of things actually, 2 books, Bad Girls at Samaran, Sexuality and Sterilization in the Southern Juvenile Reformatory in 2016, and her first book, Labor of Innocence, Forced Apprenticeship in North Carolina from 1715 to 1919, both books with LSU Press. There have been lots of articles. She worked here with us on the phenomenon of farm workers, farm worker labor, particularly in North Carolina, and the forced labor within it. She's been working for quite a while on helping pull this panel together, as has Lou. So, Karen, I'm going to turn it over to you. Thank you.
Thank you, David. Thank you very much, David, for the introduction, and thanks to you and to the Gilder Lehrman Center for initiating and sponsoring this discussion on this very important topic. I also wish to recognize C.deBaca, who organized this panel, and the staff at the Gilder Lehrman Center, particularly Michelle Zaks, Melissa McGrath, and Daniel Vieira, who made it all come together. I am moderating from the perspective of a historian, not a lawyer, so forgive me if I cut in and ask that we rephrase technical details for a general audience. We're going to have about an hour discussion by the panelists and 45 minutes of discussion with the audience. So we're going to aim for 50 to 60 minutes for them to answer some questions more broadly, and then you guys can launch in to your heart's content. We are here to talk about prosecuting slavery in the late 20th century. The 13th Amendment, passed and ratified in 1865, declares that neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States, nor any place subject to their jurisdiction. Over 100 years later, what does it mean to enslave humans in the U.S.? Another way of phrasing this question is to ask, how do we recognize when someone is coerced into a condition of slavery or involuntary servitude? This is the question that prosecutors today must address in bringing criminals to justice. As Supreme Court Justice William Brennan asked in 1988, what kind of coercion do we criminalize? What kind of coercion do we permit? These are the questions this symposium seeks to address. Our panelists served as federal civil rights prosecutors from 1976 to 2006 and directed the U.S. Department of Justice Civil Rights Division Involuntary Slavery and Servitude Program. Significantly, they reshaped U.S. law and practice from the 13th Amendment anti-slavery roots to broader definitions of human trafficking, including forced labor and sex slavery. The influential U.S. Trafficking Victims Protection Act of 2000 and the International UN Palermo Protocol that was adopted between 2000 and 2004 today reflect their global impact in the fight against human trafficking as much as 30 years ago. So now let me turn to introducing our panelists, and I will do so in the order in which they served as involuntary servitude and slavery coordinator. And this may help you as I go along. So here to my left is Bruce J. Berger, who received his BA in chemistry from the University of Connecticut in 1972 and his J.D. from Harvard Law School in 1975, where he was executive editor of the Harvard Law Review. Following a clerkship with the Honorable John Minor Wisdom, what a great name, on the Fifth Circuit, Bruce joined the Department of Justice Civil Rights Division Criminal Section in September 1976. He was sent out immediately to Tampa, Florida to assist in an involuntary servitude trial, that of Ivory Lee Wilson, a farm labor contractor. In the next 4 years at Justice, Bruce tried 2 other slavery cases, one in Raleigh and one in Fayetteville, North Carolina, and, using the slavery statutes, participated in the investigation and indictment of the leaders of a religious cult, the Church of God and True Holiness. Bruce ultimately settled into the law firm Hollingsworth LLP in D.C. for 30 years and was lead counsel in 8 jury trials in the defense of product liability cases for pharmaceutical companies. He left the practice of law in 2015, received a Master of Fine Arts degree in creative writing from American University in 2018, and has taught college writing at American for the last 2 years. He also happens to be the author of 19 published poems and 26 published stories, not counting the things he self-published, that have appeared over the past 10 years. This should be good. Susan J. King received her BA at the University of Michigan, her MA in clinical psychology, and her JD from American University. King spent her early career in legal services and criminal defense. In 1960, she worked as a law clerk at New Haven Legal Aid. She has worked as a deputy public defender in Washington, D.C., director of the bar program at the Commission on the Mentally Disabled at the American Bar Association, and as an attorney in criminal defense practice, also in Washington, D.C. In 1978, she shifted gears from public defense into prosecution by taking a job as a federal prosecutor at the Department of Justice Civil Rights Division Criminal Section, where she prosecuted cases in police brutality, cross burnings, slavery, and child sexual abuse. In 1983, she accepted the role of coordinator of the involuntary, 1982, pardon me, she accepted the role of coordinator of the Involuntary Servitude and Slavery Office, where she supervised and coordinated all slavery prosecutions throughout the United States. In 1986, she left the DOJ for private practice in California, and shortly thereafter rose to the position of Deputy Attorney General in the state of California, where she worked for 23 years. Retired now, she has dedicated her public service to child welfare and family services. Ambassador Louis C.deBaca coordinated U.S. government activities in the global fight against contemporary forms of slavery as head of the State Department's Office to Monitor and Combat Trafficking in Persons during the Obama administration. Previously, the Involuntary Servitude and Slavery Coordinator in the Justice Department's Civil Rights Division, he was one of the United States' most decorated federal prosecutors, leading the investigation and prosecution of dozens of modern slavery cases and developing the, quote, victim-centered approach, which we'll hear more about, that has become the global standard. Ambassador CdeBaca is an Open Society Human Rights Fellow and is in residence at Yale University's Macmillan Center, where he is the Rabina Fellow in Modern Slavery at the Gilder Lehrman Center for the Study of Slavery, Resistance, and Abolition. And just before we go into our panel questions, I want to point out to you 2 handouts that you have in the audience. The first one is this spectrum of forced labor that Lou and I have been working on for months and are finally debuting today. This basically demonstrates to you a range of different forms of forced labor besides chattel slavery, which is probably the kind of forced labor you might be most familiar with. You'll see at the top that chattel slavery is up here at the top of the state actions or state statutory actions. And then you'll see other forms of forced labor in the bottom that are more one-on-one or individual actions. The kind of forced labor we're going to be talking about today are in the green and blue blocks. If you see that there, you're going to be hearing about peonage and involuntary servitude, and you'll probably also be hearing about sex trafficking and maybe also some document servitude. So that's what I wanted to show you so you have an idea of the kind of forced labor that we are really faced with, especially in the 20th century and in the 21st century. The second document is a timeline, so that you may have some more bearing as it's a reference when you start hearing some of these prosecutors talk about court cases that, we're going to try and keep away from technical jargon, but in the instance where you might be confused, you have a reference point and a bibliography on the back. Okay, I want to now move into letting our prosecutors tell their stories. And so the first question is a very simple one for them to answer, and that is, what was your first experience when you understood slavery still existed in this country? So I'm going to ask our prosecutors to address that question. When did you first understand slavery still existed in this country? And we'll do it in the order of the time that they served. Bruce, and then Susan, and then Lou. And then we'll proceed to the next questions.
Okay. Thank you. First of all, thank you very much, Karen and Lou and David, for the invitation to speak about a very important part of my own professional career. As you heard, I started the Department of Justice in 1976. I came right from a federal clerkship where slavery wasn't an issue. I think I was completely unaware, really, of slavery in the United States until I got to the Civil Rights Division. I didn't even think I learned about it until I was there, and I was there for a couple of days, and they said, we have a trial starting in a few weeks. We're assigning you as a junior attorney. And then I learned about it. And I learned about it by reading, the prosecutorial files and the indictment and talking to the people who were at the office and the lead trial counsel whose first trial this also was, I should say. So there were two of us trying our first cases at the same time, and learned about it doing the work.
If you don't mind, just sort of describe what kind of slavery you witnessed.
So on your handout, this is referred to as the United States versus Bibbs. This is a crew, I think of it as an Ivory Lee Wilson case because he was the head honcho. Farm laborer Bibbs, I think, was a subordinate. But they migrated from North Carolina to Florida, depending upon the season. The indictment here was returned in Tampa. And so in Tampa had been working in the orange groves. So I didn't observe the field. I mean, I was there right at the start of the trial, unlike cases in North Carolina where I had an opportunity to go out occasionally and see what was going on. But as you'll hear from many of these cases, they involved people who were gathered often in urban centers where homeless or out of work individuals were looking for jobs. They would typically be invited to join a group in a van, promised that they would go to work and make a lot of money. They were always offered wine, and it's always wine, I think, to encourage them to get in the van. The van doors would shut. They would drive off places they had never been before. In the morning, they'd get up, stumble out, and there would be the crew leader telling them that they all were in debt to him for transportation and wine for $100 or $200 or make up whatever crazy number you want to make up. And no one leaves this camp owing me money. And they were shows of force right from the beginning. And so they were taken out to whatever the fields were, and they worked. And many of them, sorry to say, stayed for years because they felt it was impossible for them to leave, and many of them knew finally no other life but then to stay and work for the crew leader.
My first slavery case at the Civil Rights Division involved a domestic servant. And I think, to me, the most shocking thing about the case, she was, I think at the time I interviewed her, she was 15. She had been purchased by her captors in Sierra Leone, I believe for $200, from parents who were illiterate, and the defendants, who were Pakistani, promised the parents she would be well educated and well cared for in the United States. This case arose in Tampa. I was assigned to help a very senior legend lawyer on the case and went to Miami to prepare for trial. And I don't remember how many days before the trial was to begin, but 2 or 3, the judge in the case got a letter from the defendant saying, "We're gone." And because they had come in through Canada, we called the Canadian Royal Mounted Police and tried to locate them unsuccessfully. But the part of this case that really shocked me, I think, was the actual purchase of a human being to enslave her. I mean, I've known about slavery for a very long time. I wasn't so surprised about the actual holding against her will and forcing her to do work 17 hours a day and having her sleep on a pallet, but the purchase was just shocking.
Well, so when I got to the Civil Rights Division, it was right after the Rodney King case. And I think a lot of us that were coming out of law school in the early 1990s were very motivated by that. Not just the King case itself, but by police brutality. And I think 3 of us baby lawyers who came in on the honors program very much thought that was going to be our lives. We all had our regular dockets of police brutality, racial violence, et cetera. And I kind of vaguely knew that there were a couple people in the section that were working on a case, the Carrie Mae Bonds case, which is kind of the last of the African-American crew leaders in the Carolinas, and then the Alzanki case, which was a domestic servant case that was going on right after I got there. But very much what happened was that the Involuntary Servitude and Slavery Coordinator at the time, Carla Dubinsky, suggested that I go with her to meet some activists who were in from Florida, who were frankly there to yell at the department as to why we hadn't been doing anything on their case. Those are the folks who later grew into the Coalition of Immokalee Workers and were actually, some of them featured at the GLC Modern Slavery Conference this last fall. Because I was one of the only Latinos in the section, I think I ended up getting put on the case under the theory that I could talk to the witnesses. Nothing really happened for a while until Tom Perez became a deputy, Tom who now is the head of the DNC. And he pulled me and Leon Rodriguez into his office and said, "Nothing's been happening on that case. I'm going to put the 2 of you, considering that you can go talk to the witnesses, I'm going to give you 6 months. Go see what is out there. If there's smoke, maybe there's fire. But if not, you can do a nice quick closing and we'll be done with it." And we went down to the swamps of South Central Florida and we found what over the next 10 years started to become described as ground zero for modern slavery. And so I think that was definitely how I got into it, but almost from the beginning, we started seeing just how structural it was, and we had to have a different response.
When you became ISS Coordinator, would you please describe the state of the position when you entered?
And you're looking at me first, Karen?
Yes.
Okay. So as we gathered together our forces for this, and we've had some discussion about when and if this actually happened. It must have happened because obviously there are 2 ISS coordinators sitting to my left, and they, fully believe that they were holders of that position. I couldn't really remember that that position had formally been given to me. What I did remember was that I was informally involved in trying to coordinate, not all involuntary servitude cases, but at the time I was focused on the migrant labor cases, which is pretty much all we had in the office. So, so the position, if it did exist, is one that I guess I initiated and proposed. I've gone back to find old documents that I managed to save amazingly for more than 40 years, and found a memorandum in which I was writing to section chief at the time, I think it was Dan Renzel, that we should have somebody to coordinate these migrant cases. And I offered reasons why it might be good, and among those reasons were to try to bring in people from Department of Labor and try to bring in people from the criminal division and work more closely with farm labor legal action programs. And apparently I did this informally then for about a year or so until I left. So all I can say is that the program, while I was involved with it, was very incipient. And I'm happy to see that it progressed and it ended up so well attended to with such an important caseload. But it started out in a very tiny fashion.
I will have to say, though, that as we were looking at all this, we found the New York Times article, which talks about Bruce leaving the position. So while he might not have started it with fanfare, it was front page news, and he didn't leave under a cloud or anything. It was a very positive thing.
That was the first, only, and I'm sure last time I'll ever be quoted in the New York Times. And I wasn't aware of it until you mentioned it to me. And then I did find that article in my box of documents from, the way back past. So anyway.
Okay, I guess when I became the coordinator, it was mostly because I was the person in the office trying the most slavery cases. And so my name was like out there. So people were calling me and asking how to prosecute cases, should they prosecute cases, how could we do this? So I just sort of started giving advice, and one of the things I had experienced in some of my early cases was that the FBI agents didn't quite know what to do with these cases and how to handle them and how to deal with the witnesses and how to keep track of the witnesses who they were called migrant workers for a reason. They kept moving around, and often all we had were nicknames. We didn't have their full names. Anyway, so I started doing some trainings. I think I did one on the East Coast and one on the West Coast. And at that point in time, most of my cases had involved migrants. I subsequently became involved in some other kind of strange cases. One was a cult case. One was another domestic servant case. So I guess if I had to define my contribution, it would be in trying to encourage the FBI to investigate these cases, to contact us early on to get guidance so that they could be properly investigated.
Yeah, I think that as Susan says, I mean, it's hard to figure out with the ISS coordinator position how much of it is that you're the person who has the most slavery cases on your docket versus how much other things you're doing, because it was always a position that had responsibility but no authority. The authority in the criminal section is with the section chief and the deputies. And so while you end up being responsible for all the slavery cases and you end up having kind of a quasi-supervisory role on them, the actual supervisor is the deputy chief. And so you'd end up having situations, what I inherited was both with Steve Dettelbach and Carla Dubinsky before him, you'd have somebody who was doing a lot of the types of things that Susan had brought in as far as training or making sure that cases were somewhat standardized as far as people's approach. kind of buzzing around the office, making sure that people were charging under the same theories, et cetera. But then you'd be off on your own case, for 6 months or a year, in grand jury somewhere, and maybe during those months, things would be a little bit on hold as far as the program was concerned. And so it was, I think, a somewhat informal type of thing. That was no longer something that we could sustain by the mid-1990s because the level of cases was getting to be too great, and they were hitting the media and they were hitting the public with such heat that the department and the division needed something that was more than just, oh, you're the person who does the cases. And specifically with the El Monte case in California with the 72 Thai garment workers who were found chained to their sewing machines, the Flores case, which Dan Rather wanted to kind of make his version of the Edward R. Murrow Harvest of Shame documentary, and the Deaf Mexican case in New York with the people that were begging on the subways. Those were all hitting right at the same time that Hillary Clinton and others on the international front were seeing problems with both sweatshops, sex trafficking, et cetera. We were able to take the Involuntary Servitude and Slavery Coordinator position and then kind of turn it into something that became much more formal very fast to be able to respond to what the White House needed in light of a lot of these kind of high-profile cases.
And the new formal title.
Well, eventually, we started the Worker Exploitation Task Force, which was co-chaired by us and the Department of Labor, did that kind of interagency work that Bruce had mentioned. In fact, we used a MOU, a Memorandum of Understanding, that I think Bruce had negotiated between DOL, INS, and FBI about how to not deport victims. We used that as the beginning of the Worker Exploitation Task Force. But then by the time the Trafficking Victims Protection Act gets passed, with a lot of the things that we needed as far as tweaks to the law, this term human trafficking becomes so dominant that by 2006, we basically dismantle the ISS loan coordinator and start up an entire human trafficking prosecutions unit.
Excuse me, so in the sake of historical accuracy, I did not negotiate that memorandum, but it is the kind of thing I thought we ought to do, so I don't know why
Probably suggested
I
the
wasn't
memorandum.
able to do it, and I'm not saying I didn't have support from the office. I'm not sure really, why all the things that I was suggesting never came to fruition, partly probably because I was doing other things at the same time. But so whoever actually negotiated it, it's not me.
So it's interesting to point out that, just so the audience notes, that in the 1970s and 1980s, there was one person in charge of prosecuting slavery cases. This gentleman sitting here, and then when he left, this lady right here. And when Lou gets the position, he then is able to muster some of the forces needed at the time because of the way the press is handling some of these cases and making them more publicly aware into working it into an entire unit, a task force, and then a unit. So so it's kind of remarkable that these two here on my immediate left were involved in such a solo enterprise almost. I mean, there were people helping them, but it was very much a solo enterprise at first.
But can I comment on that, Karen? So we didn't have a lot of cases back then, okay? I'm sure the cases were out there to be made, if they could have been made, but they weren't being made. Okay, we had 3 cases in the 4 years that I was in the criminal section that I was involved in trial, including the one when I had just gotten there and one right before I left, in one of them. There had to be more violations out there, of course. The same people you later prosecuted were out there all during this time. It was the difficulty of trying to get these cases made, which enabled one attorney to try the 3, be involved in 3 of the trials.
Mm-hmm. So that brings us to this next question that I'm really interested in hearing you comment about, and that is, how did you see your role squaring with the overall mission of the Civil Rights Division and the language of the 13th Amendment? Was this something you were cognizant of? Were you thinking about the 13th Amendment specifically?
So, obviously, we were aware of the 13th Amendment, but it wasn't foremost, in my mind. I mean, there was a statute. So to the extent I was looking at any document about, okay, what does it take to prosecute a case, it was primarily Section 1584 of the Criminal Code, with the exception of the last case that I tried. And we were aware that these were, post-Civil War statutes, but I don't think there was a focus, at least not on my part, on the 13th Amendment. And in terms of the Civil Rights Division as a whole, I mean, I wanted to work in the Civil Rights Division and frankly wasn't even aware I was going to go to the criminal section, I think until a week before I came to Washington from New Orleans. So I saw it as an important part of the mission. I was very happy where I was. We had little contact, at least I did, with the other sections, but we saw ourselves as part of a very important mission.
And I think I would say the same thing, not so much about the 13th Amendment. I did think about the 13th Amendment. And I think in one of the cases I tried, and I think it was Kosminski, we actually alleged a conspiracy to violate the 13th Amendment. And I think that was not a good way to draft the indictment in hindsight, but I don't know. I was always very conscious of it. I don't know that I thought about the criminal section and the mission of the other parts of the Civil Rights Division. I mean, to me, they were all sort of headed in the same direction, but the criminal section was the only part of civil rights doing actual criminal prosecutions. Everyone else was doing other things. So I don't know, I guess I thought we got more bang for the buck because we could actually put people behind bars for their bad behavior.
How poetic.
Nice way to put it, yeah.
Yeah, that's actually more diplomatic than I could have put it.
Thanks.
I think that one of the things that during my tenure that we saw was as we needed to have a policy response, not just because there was all this interagency work to knit together, but that we were dealing out in the world and we were dealing with the wreckage of this Supreme Court case that Susan mentioned, the Kosminski case. And we were trying to work our way back to what Susan and Bruce and others in the section had been able to obtain in their cases. And so we were very aware of the ability to use the 13th Amendment in its second clause as far as the congressional power to enact legislation to further the 13th Amendment. So we were both doing Section 1584, the statutory, and the conspiracy charges as far as taking the 13th Amendment into court with us. But maybe even more important what we were doing is we were getting up to Congress and out into the UN with the language of the 13th Amendment and basically saying the 13th Amendment is powerful enough to carry legislation that will fix what the Supreme Court did when they limited our application of it. But to do that, we had to use the second clause of the 13th Amendment rather than the simply shall not exist clause. It's the Congress has the power to enact legislation to effectuate it.
Lou, would you also comment towards the end of the millennium there, would you also comment about how you were trying to encourage Congress to think more broadly about the 13th Amendment and how to enforce the 13th Amendment through the Trafficking Victims Protection Act?
Certainly. One of the things that was interesting about the late 1990s, early 2000s, and this is, I think, something that happened more in the early 2000s when the Bush administration kind of went all in with this new label and new word trafficking, is there were some people who said, well, this trafficking in persons is not part of the mission of the Civil Rights Division. Because the other sections were doing more 14th and 15th Amendment non-discrimination cases. Whereas in the criminal section, we're doing both 13th and 14th Amendment cases, but we're also doing cases under the 5th Amendment, not having unreasonable seizure. We're doing cases under the Eighth Amendment with cruel and unusual punishment, Fourth Amendment, and even the First Amendment with the ability to associate with people of other races in your home. And so the criminal section, I think, always stood a little bit apart from what people tended to see as, quote unquote, traditional civil rights. And to the degree that there was tension between the criminal section and some of the other sections, it was sometimes that other sections didn't always like the fact that we put people in jail, just kind of in general. But then I think there's also what those kind of tools and the fact of the non-discrimination principle being something that was not really what the criminal section does. Having said that, what we recognized in the late 1990s is that if we were going to get back to being able to use psychological coercion, if we were going to get back to something that fully recognized the vulnerabilities of victims, especially since we had now lived through a rotation of victim class. The dominant victim class in the United States was no longer African American. For the first time in 370 years, the dominant victim class was starting to become immigrants.
Lou, let me interrupt and ask you to first explain for the audience the different forms of coercion you all were sort of struggling with in order to prove.
Well, so back in the day, here in Ann Arbor, sorry, here in New Haven.
That's where
right,
they
exactly,
had the wrong
exactly,
kind of coercion.
Exactly. Back in the day in New Haven, there's a case, the Shackney case, which is a chicken farm just outside of a town, a kosher chicken farm. And the people were being held through a combination of threats of deportation, isolation, et cetera. But the Second Circuit basically holds that all of the types of coercion that were being used against this immigrant family, child labor, threats to turn over to the Immigration Service, et cetera, that those were not sufficient to show a violation of either Section 1584 or the 13th Amendment. Because, the court said, you have to have force, threat of force, or threat of legal coercion tantamount to imprisonment. And deportation back then, deportation is not a punishment. Deportation is a way to get a free ticket home to Mexico. You can't threaten to hold somebody in servitude by threatening to release them from their servitude and sending them home. In other words, a lot of really good logic games on the part of the Second Circuit judges. What Bruce and Susan and their generation was able to do was to tear down the Shackney decision and to start having the enforcement of these crimes more accurately reflect the lives of victims, whether they were immigrant victims or whether they were vulnerable African American or even white American victims made vulnerable by whether it's mental disability or other things. And the Kosminski case then takes us back to force, threat of legal coercion. So in the late 1990s, what we were doing was responding to Justice O'Connor's suggestion that if we wanted something that was going to be more psychologically based, then we needed to get Congress to do it, rather than litigating our way to that point.
Even though she created a whole different legislative analysis of 1584 in her decision. I just had to throw that in there because, really.
So I want to dig into this just a little bit deeper because there are some really, what Lou is talking about is that both Bruce and Susan experimented, I think is a good way of putting it, sometimes successfully in the short term, sometimes not so successfully in the short term, but I think in the long term, very successfully, with different strategies in the courtroom in defining and broadening the idea of coercion. What does it mean to coerce someone so that they are enslaved? And so, first of all, I would like Bruce to talk about, just briefly, how he sort of approached that. He, in particular, in talking about the doctrine of a climate of fear.
So the idea of a climate of fear was foremost in all the cases that I was involved in. It's not something that I invented. I mean, in the first trial, I was the one, managing the witnesses, keeping track of the victims, making sure they came to court. So I'll credit my partner in the case, Mike Johnson, with the excellent closing argument that led to the conviction in that case. All the cases that I was involved with at that period of time were under the shadow of Shackney. And as I recall, we weren't trying to find ways around Shackney. We were trying to find cases where there was sufficient actual force, sufficient threat of force, that it would have satisfied the Second Circuit in Shackney. Not to say that if there were other kinds of coercion, we wouldn't have talked about them, but because it closed a lot of cases too, where we didn't think there was enough evidence of force, where there still might have been, some kind of a threatening environment. But if we didn't think we had enough of a case where there were reliable witnesses to say he pulled the gun, he threatened with a gun, shot the gun out to make people afraid, that was the kind of case we said it's not worth prosecuting at this time. We're going to put our prosecutive resources to cases where there was force, of which there were some. And some we lost. Okay, so the second case I tried was an acquittal. Then the third case was a little bit different still, because we didn't try this case to say that these people had actually served as slaves or they were not forced to work for a period of time, because there were issues about whether they had actually stayed at the camp. But we prosecuted under a different statute, 1583, which is again from the post-Civil War era, in which the theme of the prosecution was there has been a kidnapping for the purpose of holding these people enslaved. So they were migrant workers who had tried to go away. They were tracked down. They were forced back into the truck. They were brought back. But shortly after that, some nuns, I think, some reliable third-party witnesses happened on, and they got out. And so they weren't actually forced to work. We used the statute still successfully to prosecute Tony Booker. So we were starting to experiment with different statutes to use to try to broaden the kind of case that we thought we could prosecute. And I want to thank, the farm worker legal aid people who helped me see the light on Section 1583 for that, because that was originally a case that we had closed. And then when I spoke with them and they pointed out there was another statute I hadn't really considered, and we went back, we recognized that, there's another way to get these guys. So in the jury instructions, there was climate of fear language, I believe, but at least I didn't feel like we were inventing something new or trying to limit the effect of Shackney.
So just to let you know, I spoke to one of those farm worker services attorneys, and they were saying that they had been threatened by the same labor contractor, so it was in their survivalist best interest to get you to prosecute that labor contractor.
They didn't tell me that. When I so that's basically how I see that.
Yeah. Susan, talk a little bit about the experimentation you did in the courts.
Well, I feel like we've been talking about Kosminski and nobody knows what the case is about. So it involved a dairy farm outside of Ann Arbor, Michigan, with a mother, a husband, wife, and son, who the wife basically kidnapped one of their slaves from walking down a country road. And I don't remember the details of how they got the other man to work there, but one of them had an IQ of 60, one had an IQ of 67, I believe. I think they were in their 50s at the time, 40s or 50s. They were working like 17 hours a day. They lived in a rundown trailer. They had moldy food to eat. They were told, one of them had been in a training facility as a juvenile, and one of the threats was to send him back there if he didn't work, and they were isolated from their families. They were told their families didn't care about them. The neighbors were told, don't talk to them. They're under our legal, I think they said guardianship, legal control. So they were completely isolated. But they did leave the camp, and they did, the farm, and they did talk to neighbors, and eventually one of the neighbors thought conditions had become so dire that he contacted a social worker who came in and interviewed them in front of the soon-to-be defendants, where they didn't really reveal very much. And then eventually enough investigation was done that I got a phone call from the FBI. Can we do this? How should we do this? Anyway, and frankly, I don't remember my exact thinking about how we indicted this case. But I do recall that we had an expert who came to court and testified that they had been psychologically coerced. And while there had been some violence and some threat of violence, we focused on the psychological coercion. And they were convicted, and they were sentenced, and they appealed, and the Sixth Circuit said, that was a lot of hoopla from a non-expert witness, from somebody who should never have been qualified as an expert. And furthermore, you need force or threat of force. So even though there was evidence of force and threat of force, the case got reversed. It went to the Supreme Court, and the Supreme Court basically said you have to have force or threat of force.
And so that experiment,
Well, in the short run, I'd say it failed. In the long run, I think it led to the legislation that Lou was talking about, which broadened the scope, referred to it now as human trafficking, which, for reasons I cannot explain, cannot really even articulate, people are willing to talk about human trafficking. They don't really want to talk about slavery. If you say, I prosecuted slavery cases, they tend to just kind of drift away. So, long term, I guess maybe it was a good thing.
one thing I'd like to do is to share the video clip that you brought that sort of demonstrates the culture of violence in these environments. And this one in particular is about migrant farm workers, but there's also a culture of violence in the cult cases that you're talking about, and there's also a culture of violence in the domestic cases as well. So I think this might, I'm going to show about a 3 to 4 minute clip from the video you provided for us, which is from a newscast that was in the 1980s. And let me just show that, and then we can discuss it.
And involves a Florida case. Oh, turn my phone off.
Of enslaving migrant workers. All four are so-called crew leaders, the middlemen between the farm workers and the corporate growers who hire them. The indictments against the accused stem in part from an award-winning investigative report that appeared on ABC affiliate WTSP in Tampa, St. Petersburg last summer. Mark Feldstein, then a reporter for WTSP, spent 5 months working full-time on that investigation. Feldstein is now a correspondent for ABC News. Here's how he tells the story.
They are accused of holding men as slaves. Willie Warren Sr., his sons, Willie Jr. and Richard, farm labor contractors or crew leaders, now on trial for the crime of enslaving migrant farm workers.
I've wandered all over your green growing land.
It is here that the story begins, in the fields and groves of the rural South.
I'll lend you my hand.
It was here that migrant farm workers say they were held in modern-day bondage.
See me and then I come.
James Williams, 63 years old, sick with tuberculosis. He's just one of dozens of farm workers who say they were forced to work for the Warrens against their will.
Grabbed me in my car and threw me back in the truck.
Len Gaston, 64 years old. He says he was trying to hitchhike a ride to the store when he was picked up by a passing van. But instead of going to the store, he says he was taken against his will to a cucumber field. The driver was one of Warren's men. What'd he say?
No, you ain't going nowhere. You're going to stay here with us.
The crew leader was Willie Warren Jr., the son of Senior. Gaston says Warren Jr. forced him to work 15 hours a day, 7 days a week. The pay, less than $1 a day, much of it in cigarettes and wine. Gaston says that when he tried to escape from the camp, guards caught him and brought him back. He says Warren Jr. was waiting with a rubber hose.
He whooped me with it. I couldn't walk in about 2 or 3 weeks.
Where did he whip you?
All over.
Farm workers say that after being kidnapped, the Warrens took them to isolated work camps, like this one in Central Florida. Why didn't you just run away?
Run what way? How you gonna run away and don't know where you going through the woods?
Trying to slip off from the camp, man, it's just like trying to break out of jail. You gotta wait and you gotta bide your time. And you better be right. You better not get caught trying to slip away. Then you're gonna get hurt.
Workers say that because they were so isolated, they were forced to buy food from the Warrens at high prices. And you actually paid $1 for a piece of soap?
That's right.
Because of the high prices, farm workers stayed in constant debt to the Warrens. It became a vicious cycle. The more they owed, the longer they stayed and worked to pay off their debt. And the longer they stayed, the more they owed.
And the whole 5 years, it wasn't mine up to $100. And the whole thing.
In 5 years, you didn't make more than $100?
I don't believe it was that much.
What the hell is this?
James Moffis gave us pay receipts showing how his debt carried over from week to week. Moffis told us he didn't understand how he got in debt to Warren.
I still don't understand it.
We tried to talk to the Warrens about all of this.
I'm gonna take that camera right from you, and you gonna get out my you out my while I found your in that ditch.
But they wouldn't answer our questions. In fact, the next day, a friend of the Warrens threw hot water at us, then hit me in the head with a pot. I had to get stitches in the emergency room of an Orlando hospital. Migrants who work for the Warrens say that kind of violence is common. They're adamant about what happened.
Mister, my father reached out in heaven. He know I'm telling the truth. And I can swear that on 7 stacks of Bible. Because, see, I've been there. I know.
In part 1 of Mark Feldstein's report, he focused on the churn.
Yes, the film continues on with some interesting discussion more about the technicalities. This would have been 1983.
Maybe.
Yeah. So the second part of the film talks about the technicalities about how the Department of Labor had been showing violations, but had not really taken Willie Warren out of the field. But what I'd like for Susan to comment upon is how you saw, or what evidence did you see of that kind of cultural violence, and how did that differ from cultures of violence in those other environments, like the cult cases and the domestic cases?
So I didn't, of course, actually see this. I mean, I saw but to me, Willie Warren Jr. was just intimidating. I mean, he was just kind of a scary thug. And so if you are an undereducated, impoverished person, and he's walking around with a rubber hose, and you know that people who've tried to escape have been brought back, you're not really going to take any big risks. So in the cult case that I tried, they actually built a wooden stockade and used to publicly beat people with an axe handle that was called Big Mac. And the cult leader had drawn up a contract that adults agreed to be beaten if they didn't comply with the rules, and that their children could be beaten. And of course, this was part of the defense in the trial. Well, they agreed to this. But in that case, a child was beaten to death. Part of it publicly, but part of it later, not given any medical treatment because he wasn't doing his work at the camp where they all lived. With one of my domestic servant cases, one of the victims who had a slip of paper with a telephone number on it, when the female defendant in that case found the slip of paper, she burned the woman's hand with a hot iron and took the paper away. And most of the time, when the woman left the house, she actually physically unplugged the phone and took it with her. And the workers were locked in the house.
Lou, would you mind describing some of the culture of the kind of culture of violence that you witnessed, especially in the Cadena case and in Flores?
Yeah, one of the things that, and I never want to say it could have been worse, but everybody in the criminal section who was in the courtroom at the Supreme Court when the Kosminski case was being misargued by a political appointee, I think felt that everything was over. Is that's what I've heard from a lot of people, is that there was like, okay, well, I guess we're going to have to do the other types of cases because this is just so horrible as to what just happened to the enforcement program. But one thing that the Kosminski case didn't do is it didn't do away with the things that were in the reported cases that Bruce and Susan and a couple of their counterparts had done, the Booker case, Bibbs, Harris, Warren, et cetera. Those ideas of the climate of fear, that not having an affirmative duty to try to escape once you have been placed into a climate of fear. All of those things survived post-Kosminski. And when we were trying to pick up and rebuild, those were the tools that we latched onto very quickly. And I think that what we saw, whether it was in the Cadena case, for instance, which is one of the first cases that we were not only coming back to do slavery cases, but didn't see the reason why we shouldn't use the slavery statutes in cases of forced prostitution. Those ladies and young girls in that case seemed to us, having just gotten done with the prosecution with what became the Coalition of Immokalee Workers, of Miguel Flores, the crew leader, what the Cadena brothers were doing to their victims seemed basically identical, but for the fact that those women and girls were not out in the fields. And so we saw the same type of thing as far as low and mid-level managers who were assigned to keep watch on them, storytelling about people who had been hurt by the bosses, sometimes a punishment in front of the other workers so that everyone could then refer to that. You don't have to do it every day if you do it once dramatically for a while. But then, that notion of kind of inculcating the climate of fear so that people aren't going to try for the devil that is not known. They don't know who's on the outside of those trailers. They don't know where they would go to get help. They're afraid of the police. They're afraid of the immigration service because of what the family is telling them. All of that, we were able to then use these concepts of climate of fear, no affirmative duty to escape, et cetera, and start to rebuild an understanding of what involuntary servitude and slavery actually was.
And in particular, in that Cadena case, these young girls were being forced to have sex with clients every 15 minutes, and that they were so degraded and humiliated and in so much pain from that, it was really difficult for them to even think ahead to the next minute because of their survival.
One of the things that we saw in that Cadena case was that the one day a week that the migrant workers would be allowed off of the camp was the day that the women in the cadena trailers were having to be with anywhere between 30 and 45 men during a day. And you end up having just these heartbreaking instances of, women taking an extra 10 men so as to try to spare the 15-year-old girl in the house from having that kind of crushing load. You see, spiral notebooks where they're trying to keep track of how many people they've been with in a given day, because they're hoping that they can then present that and say, I've paid off my debt, now can I leave? But in the same kind of pink spiral notebooks with, other pages where there's hearts and, trying out the last name of the boy that they like with them. I mean, you just see them being 16 and trying to recapture that, and then a list of tally marks of 20, 30, 45 men in a given weekend. Yeah.
Thank you very much. And I think what I'd like to do is open up for the audience to ask questions, because I'd like to see what kinds of questions you all have and how that you might have them, how our guests might be able to answer those. So I'd like to just invite anyone to come up to one of the microphones here and to pose a question for our panel.
And while that's happening, can I end the cadena case on a happy note?
Yes.
Okay, thank you. I just realized that cadena left the stage there on a very horrible note. One of the things that's so important when we look at the Trafficking Victims Protection Act is that it is not simply the Kosminski fix that we had initially been hoping for, but it actually brings in victim protection and prevention issues. So we call this the 3 Ps during the Clinton administration. And one of the ways that the victim protections, especially the trafficking victims visa, that allows you to take people who are in the United States undocumented, without inspection, et cetera. And this is right after the 1996 Immigration Reform and Control Act, which had done away with the ability of foreign people to access federal public benefits. It had had welfare reform, had come in and done the same thing. They'd stripped the ability of even the INS to let people stay in the country. The way we were able to overturn all of those and get the T visa and the U visa for crime victims, which have, I think, revolutionized a lot of the ability to help victims, in many ways is credited by observers as directly the outcome of the testimony of one of the cadena victims, a woman who testified under the name of Rosa, I think. And by the time she was done, even the anti-immigrant senators on the panel were saying, we need to have a T visa, we need to have solutions so that what you went through has some kind of meaning. And I think that, to me, that's the thing. It makes none of the suffering that they went through worth it. But I was in Miami a year ago and having coffee with the lawyers who still represent a number of those women, and they were saying that the FBI agent from that case continues 20 years later to turn down promotions because he's afraid that if he gets transferred, that there will be nobody there to be with and support these young ladies. But they are, seeing their children now being able to go to college in America. Some of them are the most valued employees in the places that they work. And others continue to try to claw towards any kind of being able to make it through the day. But the fact that I'm able to actually say, here's these, 18 women or so from that case 20 years later, it's because something did come out of what they went through. So, just wanted to make sure that we didn't end the cadena case simply on the horror that happened before the actual case.
Well, first, thank you to all of you. There've only been a half dozen or so times in my life when I wished I went to law school.
Get over it.
No, I'm over it. But this is one of them. This is a story, it seems to me, you don't feel this way, I'm sure, of heroic lawyering through this roller coaster of what you had to do. But here are just a couple questions that come to my mind. First of all, with the 13th Amendment, the idea that you were using the second clause. I just lectured about the 13th Amendment yesterday in my Civil War Reconstruction course, and I always say, you know, that second clause was there because they put it in for future. They put it in all three of the Civil War amendments, and then I just don't talk about it. But the idea that you actually went to that clause rather than the first clause is amazing to me, fascinating, because you're trying to get the attention of Congress, you know, which you desperately need. It's amazing. And any more comment you want to make on that is great. But I'm struck here too, and just historically, how you were up against, like from your opening remarks, no one wanted to hear the word slavery, maybe trafficking. There's so little understanding when you begin to find these cases. I mean, where the minds were at, from the 70s, I take it, through the 90s into the aughts, about slavery and just what constitutes that among very educated people within the civil rights community even, is interesting. I mean, how historically did we get there? I don't know that you know all those answers, of course, but you were up against a climate of understanding, right, or a lack thereof, that this could even be still going on in America. And I can still vaguely remember seeing in the press, probably these very cases, oh, they found a farm worker in Florida who was deemed enslaved, and oh my God, you know, this is happening in late 20th century America. Now we know this has kind of been happening all along. But there's a historical climate of understanding, misunderstanding, knowledge, lack of knowledge there that you were up against. That maybe you should comment on more.
Denial is a wonderful thing.
What's that, sorry?
Denial is a wonderful thing until it stops working.
Yeah. That's good.
Can I comment? I wrote a short story once based on these experiences, because so this is, I've written some fiction and poetry about these experiences that I had, because these cases stay with me today, okay? And I've written nonfiction about it. I wrote a story once, this is about 10 years ago, so when I was starting to write stories seriously. The name of the story was based on the name of one of the victims in my first trial. And I sent it around, and it ended up, I sent it to the Emerson Review, Emerson College in Boston. Usually when stories are rejected, you don't get explanations, just the rejections. Here I got a rejection with a note from the editor, this kind of stuff doesn't happen. So I went and I looked up the Fifth Circuit. The editor, sure, maybe a student, but so I at the time copied it, the Fifth Circuit opinion and sent that, or me emailed it to her, but never heard back.
But as I've been sitting here thinking about being the involuntary servitude and slavery coordinator, one thing I do think happened is the more cases we prosecuted, the more cases we heard about. And so during my 8 years at Justice, I was involved in 8 slavery prosecutions. And it wasn't like one a year, it didn't work out that way. There could be 3 in one year and none in another, but as headlines hit in places like Ann Arbor, Michigan, and then not so far away in Grand Rapids, 6 months later, is another slavery case, I think you start to hear more about it.
I also think, David, to your point as far as kind of a climate of misunderstanding, I mean, I would say it's willful misunderstanding to some degree. We see this in the UN system, I think. A perfect example is the pretzels to which the UN system will set themselves up so that they can talk about, under a particular recent Security Council resolution, so that they can talk about human trafficking in conflict zones, or they can talk about rape as a weapon of war, so they don't have to use the word slavery. And if rape and gender-based violence in conflict zones are more comfortable terms than slavery is, then it says, I think, a lot about kind of the emotions that come with that. And yet, the Involuntary Servitude and Slavery Program existed since 1941, when it renamed the peonage program, because that's just the legal name of what the division was tasked to do. So it was a kind of non-emotive label for the case law and the case book, but then out in the world, it's a word that makes everybody so uncomfortable. Even during the Clinton administration, when we were doing all these things under the Involuntary Servitude and Slavery Program, we ended up having to call it the Worker Exploitation Task Force. And then the sweatshop people set up the Fair Labor Association so that they wouldn't have to then really call it slavery. And we see that just recently, in Bangladesh after the Rana Plaza collapse, where people want to see that as safety accords as opposed to, and so the Bangladesh Accords for garment ends up focusing very much on safety, when the real problem is that how many people in that building were in debt bondage. So I think that even we, whether it's in policy roles or in the academy, will try to come up with whatever other word we can. The problem is that once you start coming up with those other words, those words have meaning, and it all kind of waters it down, and then you don't look at the horror of what the people have gone through. You don't look at the lives of the person who's trapped behind that fence or that apartment or what have you. This is in dialogue with David Blight.
Sixth Circuit, conservative circuit, that's where it started. I don't know how to answer that question. I really don't.
I think it's that they want something that's objective. And what's strange about the Kosminski case is that even though it was properly seen as a huge hit, the reason it wasn't a death knell is because there was a little savings clause in the same paragraph that cut off the legs of the enforcement effort, a little savings clause saying, but you can look at the subjective effect on the victim. And so even Justice O'Connor, when she was doing something that we all felt was very unfair, she was willing to go farther than the Second Circuit or the Sixth Circuit and say that maybe there is a subjective element to this. And to me, that was, and you can use climate of fear to do that. That was how we rebuilt the program in some ways, was by using that as our launch pad. But other courts would rather simply say, and we get this in the diplomatic realm as well, other countries wanting to say, no, give me the case where the person is locked in, where I can see the lock, where I can see the chain, and if it's psychological, then don't come to me and talk to me about my slavery problem. Because it's a way to define things out by insisting on having that high level of proof. This was Rehnquist Court, 88's Rehnquist, yeah.
Thank you. I do have a question. I'd like to start by thanking the three of you for your service, your work, your intellect. I'm sure at the moment that you were working on these cases, you were just really doing a good job at DOJ. But as a trained historian, and as you can start seeing, your work is really, I think historians are going to look at all of your work quite favorably, and really the long-lasting repercussions in the fight against modern-day slavery. So my question, though, is in light of this culture of fear, we're talking about this culture of violence, I couldn't help but to recognize the scenes in 12 Years a Slave, with what the piece we saw up here, with Lou's description of what happened to the women in the Cadena case. And so, and Susan, you had mentioned you had a little bit of trouble working with your FBI agents. I actually would like to see the positive side of federal law enforcement from your experiences, because you worked with the FBI agents investigating, at the time, INS, now ICE, but also with CBP. And I know a lot about Lou's experiences and just really amazing federal law enforcement agents who wanted nothing more than to help these victims get in, get out, be able to testify. So I was just wondering if I could hear from Susan.
Okay,
Yeah,
I'm happy
earlier.
to answer that. I had some fabulous agents, or these cases would not have been successful. An agent from Grand Rapids drove from Grand Rapids to Ann Arbor while I was trying the Kosminski case, sat in the courtroom all day and said, you will come to Grand Rapids, you will investigate this cult case. Do it. So, but there were other FBI agents who, I don't know if they were just uncomfortable because they didn't know where to begin, they didn't know how to do it. Some were fabulous, but I mean, you're going to have this in any agency, right? You're going to have really fabulous people. I would say overall, my experience with the FBI in these cases was remarkable. I mean, they had to, in the migrant cases, you got to figure out how to keep track of them. And we had a paralegal when I was at Justice who I actually just had dinner with last night, and I said, how did you find them? Because he found all the witnesses for my North Carolina trial. He went to Florida. He went to New York. He went to North Carolina. He got us enough witnesses to get a conviction. I said, all right, how'd you do it? I've always wondered how you did it. He said they passed out T-shirts with their phone number on it. They passed out postcards. He said when he went to, he'd get up early in the morning to go where migrants would wait to be picked up, to be taken to the fields. And he'd say, do you know Bucket Man? Somebody'd say, oh, yeah, maybe. And he'd say, I'm not looking for him. He's looking for me. He wants to talk to me. So can you let him know I'm here, and I'll be here tomorrow, and I'll be here the next day? So, very clever, very clever. But I've wondered all these years how he did it. That's how he did it. And sometimes it was the FBI who, and in the case you saw here, that reporter was in touch with witnesses, and I don't know how this was my bad, my oversight. We didn't have anyone at the airport to pick some of these guys up when they were coming in. So he'd go pick them up, bring them to court. We'd have them testify. The reporter. So you take help wherever you can get it, but a lot of times the help was the FBI.
And I think we all had nuns.
Oh, nuns, yes, we had nuns, I forgot. Yeah, Sister Catherine. There was a nun who worked with migrants, taking them to get health treatment, medical treatment, and she testified, I'm pretty sure, in that Florida case.
I had one in North Carolina.
You had Evelyn Mattern.
Right?
Her name was Evelyn Mattern.
I was just going to say...
See, I told you you'd know more about these cases than we do.
About the paralegal bill that Susan was talking, it was also the paralegal who helped to pull the migrants together in the first case that I tried. One of them he found in jail and bailed them out, as I recall.
Wouldn't surprise me.
So,
Well, and I recall from...
right before the trial.
I recall from, I've read one of the short stories that Bruce had written about in the memories of the thing. He'd sent it to me. And he's even better looking in person than his protagonist was, because of course, you always wonder if somebody's making their protagonist smarter and better looking. But one of the things that in that short story, just the notion of, you just get done with a judicial clerkship, which is a very fancy thing. You're wearing suits, you're going and having these, big thoughts in fancy courtrooms about
And
what.
a famous judge.
What,
It was New Orleans.
with a
Went out
famous
to
judge.
drink for lunch.
Yeah, well, there's that. But with a famous judge. And then you get up there and somebody says, go out and, you're going to be in trial at DOJ. And suddenly you've got 8 or 10 homeless dudes who are only
Alcoholic.
thinking to their next drink,
Right.
who you have to get into court tomorrow. And I think that's as much of, what these cases are about, is figuring out, not in a cynical way, but figuring out how can you actually make it so these stories from people whose stories don't get heard can actually end up being heard. But sometimes that means finding an open diner in the middle of the night.
So there's,
Witness management.
Yeah.
wasn't sure I was going to talk about this at this gathering, but there's a big irony in the role that I played in that case, because there's a lot of similarity between the role I was playing and the role that the farm labor contractors were playing. They were dealing with the same people. They had the same kind of objective: keep them together, keep them focused on a certain thing, make sure they don't run off, make sure they don't get too drunk to walk. We had the same issues, really. And so in addition to being part of the prosecution, I was seeing everything, in a way, through the eyes of the defendant.
I'll add, and I can add this because I've read all these transcripts. One of the ways that these migrant workers were coming back was because the legal services attorneys were filing civil lawsuits in their behalf so that they could get some kind of monetary compensation from either the grower or the labor contractor. So some of those, including Joe Romeo, who was one of your victims, he came back because he and Gary Walters had both filed civil suits, and they ended up getting a significant settlement well after your trial, your criminal trial.
Good for them. Thank you for letting me know that. I remember them.
Yes, it is.
It's a race.
This is such an illuminating panel, and it seems like it's speaking from a completely other world and other era. I wonder if you might want to speak about the current situation, if you have kept up with it. We heard a story from you of reassuring migrant workers that no, immigration wouldn't be coming after them if they testified, and obviously that would be very different now. And I wondered if you could comment on that. We've got to now have a government who's quite probably undermining all of the work. I don't mean to, I'm sure there will be cheerier questions to answer, but it looks like, they're undermining quite a lot of the kinds of work you were doing. So I wonder if you could comment on that.
Probably for me.
I think it is.
So one of the things that we're seeing with this administration, I'll back up for 1 second. I mean, what the big push of the Clinton era actually survived through into the Bush administration with some name changes and some tweakings, but then also survived in the Obama administration, even though there were some people who were saying, oh, this trafficking stuff, it's all about sex, it's all about the evangelicals, and so now when the Democrats are in, now that'll go away. And it didn't, because this is, if you root it in the 13th Amendment, then it's not about issues of immigration, it's not about issues of morality, regulation of prostitution, how the evangelicals or certain wings of the feminist community are getting together for policy victories. It just kind of becomes the day-to-day bread and butter work of the Civil Rights Division. So I'm, of course, very interested in having helped transition this through a couple of changes in party administrations as to what's happening in the last couple of years. And it's a mixed bag. On the one hand, with the closing of, not the closing of the border, but the child separations policy is a direct misuse and perversion of the unaccompanied alien minors provisions of the Trafficking Victims Reauthorization Act of 2008, which basically said you couldn't just deport unaccompanied alien minors back to Mexico. They were just being dumped on the other side. Instead, you actually had to have a way to get them into HHS custody. Health and Human Services would be able to help them out. And lawyers in both HHS and DHS last year on the child separation issues did some very careful lawyering to use that more as a sword against families than the shield that it was designed to be. So too, we're hearing very disturbing numbers from the advocates as far as the T visa numbers and some of the things that the continued presence adjudicators are doing with people who should be getting a immigration benefit kind of as a slam dunk. The nice thing is that Lucas Gutentag over at the law school and a few others are basically trying to put together, for lack of a better word, a way back machine where they can look at all of the different policy changes that are being done both formally and informally within U.S. citizenship and immigration services. So those are the scary things, and you also have very much of a focus on sex trafficking by the White House to the exclusion of almost anything else. But then when you look at some of the other things that are going on, the Department of Justice has a big push now with the community-oriented policing section, the COPS office, to try to get state and local law enforcement to do more labor trafficking cases as opposed to only doing sex trafficking work. The folks over at Customs and Border Protection just in the last few months have, for the first time in a generation, started seizing slave-made goods that are being brought into the United States because we were able to get a law passed changing the Tariff Act of 1930 a year or two ago. That happened during the Obama administration, and to their credit, the Trump administration is actually going ahead, has set up the office, and you're starting to see slave-made goods being interdicted at the border. So it's a little bit of a mixed bag, and I'm, of course, trying to encourage the part of the mixed bag that has encouraging signs and maybe trying to help guard against the other stuff. So we'll see in 2 years, we'll see whether there needs to be another transition into enforcement operations on this.
Do not let my brother ask a question. Do not let him. No.
Hi, and thank you. Now, you talked about how, slavery and servitude was something that was focused on the African American community or the African for hundreds of years. Do you see more organized crime now with the trafficking coming from other countries? Is it so much of we've seen recently, like in New York City with the nail salons, or in Florida recently with the and other places. It seems that seems to be, in my imagination, it seems to be something much more organized than maybe one farm labor, a farmer someplace in the north, or a farm corporation someplace in the south. So I'm wondering if that change occurred.
Yeah, I mean, I think that there's a perception that organized crime, and this perception goes back to the 1890s, with what was called back then the white slave trafficking panic by some people, white slave trafficking problem by others. The perception of organized crime has always been out there, and there often has been organized crime, but it kind of manifests differently in different countries and different places. So we had a huge problem in the Balkans with the Albanians, for instance, in the wreckage of the former Yugoslavia. There's been a lot of Tong-driven Chinese problems, not only in Southeast China, but in Chinatowns kind of around the world. And La Cosa Nostra, used to have this as kind of one of their pillars before they got into the drug stuff more exclusively. What's interesting is that there's this other type of organized crime that the scholars call crime that is organized. That it's the difference between, if you think of the LCN model or the Asian organized crime model as the same pyramidal structure of GM or the Vatican, and if you think of now as examples of
yes,
we'll go with hierarchies, yes. But if you look at this crime that is organized, it ends up looking something much more like the storefront Pentecostal churches or the internet. So it's a decentralized, not triangular type of organized crime. So that answer is kind of yes and no simultaneous. What's interesting though is it's the organized crime tools are very helpful. We started in the late 90s using RICO much more, especially when you had pimps that were carving up, enslaving women, but then also carving up areas in Atlanta saying, you know, we'll basically end up being a cartel that sets prices and sets territories. In that case, we used the slavery statute as the RICO predicate offense as opposed to a narcotics offense, and then bundled them all together. Even though they were competitors, we were able to say that they were a racketeering enterprise. And I think that those racketeering tools of RICO and otherwise, money laundering tools, very helpful, even if it's a mom and pop shop or even if it's a kind of a flat type of organized crime. Sorry to just give a kind of semester-long explanation to kind of organized crime circa 2018.
I will also point out too that sometimes it might not be organized crime in the way we think about organized crime. Most of these cases that are on the back of your reference sheet are almost all of these defendants are families, whole families that are involved in some kind of organized fashion, bringing in these people and keeping them from leaving, somehow enforcing them and keeping them in place. And when you are reading these transcripts and you're reading these newspaper articles, you see that all these people are linked together by birth name, you know, or by surname. And sometimes there's the Willie Warren Juniors and Willie Warren Seniors, and you see the Floreses over and over again, and you see the Cadena family. In some cases, some people aren't, they get away scot-free, but one family member gets hung out to dry by the whole rest of the family. Shackney was a family. The Colt cases in many cases were families. These are all family organizations where whole families are involved, practically every one of the cases that are on that reference sheet.
Don't let him ask a question. Don't let.
This is more an observation than a question, and I'll try to make it quick. Part of what I'm struck with in this whole conversation is how much we all live in a climate of fear. And the fear, it shows, for example, in the conversation about what language can we use to describe this and get away with it. And it's evident in how heroic these panelists were and how sort of out of sync their efforts are with the extent of forced labor that existed in the 1970s and exists today. It's really hard to do the work they did. Why is that?
He's a plant.
Why is that? Because I would suggest, and I'll just close with this anecdote and a concept I have that I'm writing something about now. When you start an economy in which the wages are locked on zero, which Reverend Barber points out that it took from 1619 to the current day to get a minimum wage that went from $0 to $7.25 an hour, you're starting with a pretty low bar.
Interesting point too, and if you'll notice on the spectrum of forced labor, the very last category in the purple there is undecent labor. And Lou and I we've had all kinds of conversations about what kind of labor that is. Low wage, poor conditions. We've even had a conversation about whether or not marriage is considered a form of forced labor.
Your husband it is.
What's the coercion involved in what you have to do to try to pay? Yep.
Yes.
Well, and this is one of the things that, Risa Goluboff over at UVA, in her just phenomenal book, The Lost Promises, Civil Rights, basically ends up looking at the work of the division. It's actually pre-division. So the criminal section of the Civil Rights Division, where we all worked, is about 20 years older than the rest of the Civil Rights Division. It was the Civil Rights and Civil Liberties section of the Criminal Division. And Risa points out that, having done a lot of work in the archives, that the economic rights were as much of a focus of the early section as were what we think of as civil rights. And so the 13th Amendment work that was being done in the 30s around what was called the anti-peonage cases was also going after bosses who were union busting. And so it had, in the New Deal version of us, I think that they were much more interested in kind of the overarching labor effects of the 13th Amendment. But again, you get into the post-war and this switch over to only do a 13th Amendment case if you can hit this really high bar, basically ends up taking it away from something where the 13th Amendment might have been used in much more powerful and frankly much more radical ways that then we necessarily end up doing now, as radical as we tried to be with it.
I have a question. Thank you all so much for being here. I think the work that you're doing and talking about is so important for us to incorporate into the work of the Gilder Lehrman Center for the Study of Slavery, Resistance, and Abolition. We really appreciate you all being here and also the interviews that you're contributing. I guess my question is, I've been thinking about pre and post 13th Amendment and the challenges that those two different kind of legal regimes pose to the big question of eliminating slavery. So pre-13th Amendment, slavery is largely legal, and the abolitionists have the challenge of, creating a climate where slavery becomes illegal and not acceptable socially. And it takes a war, basically, to make that happen. And you all are working in an arena where slavery is largely illegal. And it sounds like the prosecutions, when I hear you describing these cases, it's so individualized, is how it comes across to me, that it's this kind of cat and mouse game or shell game almost, with this moving target, and you just have to, scattershot, try to approach it, both in terms of sectors and geography and everything else. So I don't know if this question makes sense, but so in a climate where slavery is largely illegal, is it even a reasonable goal to think about eliminating slavery? What's the difference between prosecuting slavery cases and eliminating slavery as a phenomenon?
I think we can't just throw up our hands and say, whoa, these cases are really hard to prosecute, let's just quit. I mean, slavery is still happening. I just spoke to a caterer in one of the wealthiest counties in California and possibly in the United States who caters high-end home parties. And we got to talking about slavery. And she said that she believes that in some of these homes where she caters parties, that people are probably being held. They're not free to leave. So I gave her some phone numbers and suggestions of places to call, and said, you're in a unique position to observe this. Don't just walk away, do something. It is a scattershot approach, but I don't know how else you do it. It's done in secret for the most part. I mean, not the migrant cases, but the domestic servant cases. How would you know about them? You send in a spy. You send in a caterer as a spy.
I think that one last thought on that, the systemic approach, so in the Civil Rights Division in the 90s, there was a recognition that doing individual cop cases would not also necessarily have that systemic change. In no small part because police unions, defendants, lawyers, et cetera, were very good at absorbing and getting acquittals in those cases. And so this idea of the big consent decrees coming in with the pattern and practice that the sister section, the special litigation section does, which goes into a New Orleans or a Newark, and basically kind of like what Judge Justice did in the Texas prison system, kind of sits on top of it and starts to try to make systemic change. And I think that's one of the things that we're seeing with the TVPA and its reauthorizations. The changing of the intent requirement so that you can go after people who profit from this is maybe not happening immediately in the criminal cases, but since the civil lawyers can use the criminal statutes now, you're seeing bosses, not necessarily farmers yet, but hotel owners and other people who are tolerating this happening. You're seeing liability being applied higher up in the food chain, and all the conversations that we've been having about supply chain work all the way to the big corporations hopefully then put downward pressure so that Tropicana, for instance, can't just have the three levels of contractors between it and what you saw on the screen. And I think that to me is the way that it goes to that next. But it's like domestic violence in that we need to be changing, a culture of violence. We need to change women's power within intimate relationships. We need to change all sorts of things. And at the same time, if a husband or other intimate partner murders, kills, rapes somebody, then we have to go prosecute him for what he did. So it's that combination of both systemic and then individual justice that maybe we'll get for one of these days.
No. No. The answer's no.
Just your opinions on the current use of the blaming of the 13th Amendment for mass incarceration, which has been I guess in my view, a bit of a knee-jerk reaction. It would have been a famous documentary film on this called 13. Going to close one of the 13th Amendment is somehow saying if that language wasn't there, we wouldn't have mass incarceration. Your opinions of that problem?
So I'm going to try to answer that and give a little bit of a background as well, because I think for folks who aren't working on it every day, that it might be a little bit of a left field. So this idea that some of the activists have that is basically saying the 13th Amendment is something bad that was done to black folks because it has the exemption in the second part of the first clause that says, so it's neither slavery nor involuntary servitude shall exist in the United States or any place subject to their jurisdiction, except as punishment for a crime of which the person's been duly convicted. Now that is, as our Northwest Ordinance scholars will tell us, that's lifted directly from the Northwest Ordinance. So you can't say that Abe Lincoln and the bad guys in 1865 wrote that to somehow 150 years later create mass incarceration in a particular community. Really what you're talking about is a law that was written at a time where there were no prisons. Penitentiaries don't exist yet. The penitentiary movement hadn't happened. And so if you're out in Western Michigan and you're one of the 1,000 non-natives in Michigan at that point, and you commit a crime, there's not a penitentiary to put you in. And so there's kind of an archaic remnant that's in there. Now, what happens, of course, is that during Reconstruction, a bunch of the southern states use this as their way to be able to re-enslave, whether it's convict leasing, whether it's chain gangs, et cetera. And one of the things that the big push in the 30s and 40s of the anti-peonage cases in the section end up, and they didn't bring it, but they did amicuses, they worked really hard on it, results in Pollock versus Williams, which does away with, finally, the convict leasing schemes. And I think at that point, everybody for the next 75 years was like, okay, well, this issue of that incarceration exclusion is done. We got the Supreme Court to basically scratch it out for us. It's being used kind of allegorically now by folks to criticize kind of the prison industrial complex. But having lived through the 90s and having done some street prosecutions at the U.S. Attorney's Office in the 90s, you know, it was very much more decisions that were made about crack cocaine and about what to do to the young men who were selling it, who were African American and Latino. That's what got us mass incarceration, not the second clause of the 13th Amendment. So I do think that there's a bit of a education process that's going to have to be out there as far as having these conversations. Having said that, though, I think that there are some good ideas that we need to take from the fight against convict leasing schemes and take those over into the mass incarceration discussions. And I'm really interested to see if there are any litigation strategies. Certainly in detention, in immigration detention, I think that there's some things that we'd be able to do with it. So we'll see. It's on my syllabus. You can. It's the last class. We're gonna all put our heads together. Of course, next.
Susan, did you have a comment you wanted to make about that?
No.
Are there any other questions?
Thank you. Some of you may recall the article last year in The Atlantic about a Filipino family that had a domestic who they basically enslaved. You may not have read it. But what we've seen is an explosion twofold in wealthy immigrants bringing in people from their countries whom they're able to keep, as well as senior citizens communities where people are trafficked to work for wealthy Americans. And what I'm troubled by, Lou, is when you said this, it's hard to prosecute these cases. And how do you get a consent decree in these cases? Or how do you go after them? And they're exploding, and it's like we don't know about them. It's almost a subculture, but it's there.
Yeah, I think that, you know, one of the things that we've seen, and I will out you if that's okay, Harry was our lead diplomat in the Philippines. He was ambassador to the Philippines while I was ambassador at the tip office. And I think that the Filipinos themselves would say that they felt like Harry was almost the head of their task force because they realized how much he cared about overseas Filipino workers. And I think that one of the things that we wrestle with is that idea of kind of the cultural understandings that people bring when they come to the United States. And, you know, there's great case law both in the South from 100 years ago with judges saying, no, just because it's part of our culture in the South doesn't mean you get to re-enslave these people. And there's great case law having to deal with the Mexican practices of peonage, et cetera. So from legally, there's great tools to be able to say, if you're going to treat your servant exactly the way you would in Manila or Doha or Riyadh, but doing it here, then you're still guilty of the crime. But that presumes that we find out about those people, which is actually one of the reasons why I like what the Philippines does as far as pre-departure work with the formal overseas Filipino worker sector. When people are going to Bangladesh, when they're going to the Gulf, there's the trainings that end up getting done before people leave. And that's brought down a lot of the abuse on the other side. The problem is that when you have folks that are bringing people in, whether it's as teachers, whether it's home health aides, whether it's as domestic servants, and they're not the ones who are necessarily going to get covered by those outbound trainings, it shows where those gaps end up being. So I think that part of the structural response is, like we've tried to do in the Philippines, which is how do we have those relationships with the sending countries, so by the time a worker gets to the United States, by the time a foreign worker gets to Britain or to the Gulf countries, that their government actually knows about them, has shown that they care about them, and is then on record as doing something about them. Otherwise, what happens is that the Philippines government ends up having to take care of them when they are hurt, abused, even murdered, or arrested for striking back at their employers. In the Gulf, the Philippines runs one of the largest shelters, and it's all escaped workers, and they're trying to hide them from the Emirati government while they can get them back home. So it's that idea of, like, how do we empower the other governments so that it's not simply lawyers here in the United States trying to clean up damage after it's happened.
Well, I'm being signaled that we need to close up. If we could all please give our panelists a big hand, and thank you for coming so far.